Welcome. In this lecture, we're going to take a look at probation, one of the most common forms of community-based corrections. We'll start with a brief look at the history of probation in the United States, and then we'll turn to something that I like to refer to as the dueling functions. And this pertains to some of the struggles and issues faced by probation officers as they go about doing their job. We'll also take a look at what the research likes to refer to as evidence-based practices in order to get a glimpse into what makes an approach or a style or a policy of probation actually effective. Then we'll dive into looking at the causes and consequences of violations of probation, or how individuals are able to terminate or successfully complete probation. So sort of the steps and processes involved with the probation process. And finally, we're going to take a quick look at sort of the experience of probation within California. The readings that correspond to this lecture are Chapter 8 from your course textbook. So let's go ahead and get started. When we first start to look at the history of probation, we need to start with sort of the definition. What is probation? And we've seen this definition before, but just as a reminder, probation is best summarized as, in lieu of imprisonment, an offender should be allowed to live in the community under supervision so long as he or she is willing to abide by all laws. Now, the key things we want to make sure we really understand here is that probation is still a form of correctional punishment, but it is sort of in place of, or instead of sending somebody to jail or prison, we are allowing them to remain in the community. Now, these may be individuals who have been convicted of either misdemeanors or even felonies in some situations, but the court has determined that it is better to have this person serve their correctional sentence while remaining in the community, rather than incarcerating them for a period of time. And usually the agreement and the understanding is that this individual is not enough of a public safety risk that they need to be locked up, and also they may benefit from their time under correctional control by remaining in the community. When we look at sort of the history of probation in the United States, one name that is often tied back into it is John Augustus. John Augustus was a gentleman who lived in Boston in the late 1700s through the mid 1800s. He was an attorney who actually helped individuals that were brought before the Boston court by acting in multiple facets for these individuals. He would act as their legal counsel. He would pay bail and sort of almost act as sort of their guarantee, like almost like the modern day bail bondsman. And he would also sometimes find ways to assist these individuals with finding housing. And the spirit that John Augustus brought was the idea that certain individuals don't need to be locked up in jails or prisons, especially if they have rather minor offenses, or if those offenses were attributed to other underlying issues that these individuals may be facing. And it sort of started this idea of recognizing that not everyone who is convicted of a crime needs to necessarily be locked up for a period of time. And in fact, they can serve their sentence and hopefully better themselves, provide access to treatment and rehabilitation, and start to give back to the community without having to leave the community. And Mr. Augustus, as you can see, oftentimes he wasn't necessarily representing the most harshest levels of criminals. Rather, these were individuals who had, drinking problems, substance problems, children who may have run afoul of the law simply because of status offenses, or other sort of minor level criminal behavior. And as we start to sort of probe through our textbook and other material that we'll talk about in this course about the history of probation, a couple things I want you to understand, and I'm not going to go into a great amount of detail with these, but I want you to sort of, as you're doing the course reading, really pay close attention to make sure you understand some of these concepts that have shown sort of the evolution of probation over the last couple hundred years here in America. And we've seen that it's no longer as simple as, there's not just one label of probation. In fact, it's become a very complex sort of network and framework of different types of sentences, different requirements, terms and conditions, and some of those we'll hint on a little bit later in this lecture, as well as talk about later in the course. So as you're going through with your reading, please make sure you can understand the concept of judicial reprieve and how it corresponds to probation. The use of recognizance. And so recognizance does have some correlation to what we talked about with bail and sort of the idea of release on their own recognizance. Similar application in the field of probation. And also, as I alluded to just a few moments ago, about the growing nature of the growing complexity of probation, especially here in America, where it's no longer sort of a one size fits all. There are a multitude of approaches to different types of probation sentences and policies and programs that exist not just within one jurisdiction, but from one county to another county, one state to another state. So within those various modern methods of probation sentencing, please pay attention to the concepts of direct probation versus suspended probation versus suspended probation with additional sentence, a split sentence, modification of prison sentences to probation, shock incarceration, as well as intermittent incarceration. One of the most difficult thing I would argue for many probation officers is the nature of their job requires them to have sort of dual functions. As one individual, they have to sort of play both roles. And I call this the dueling functions. And probation officers are often saddled with these sort of conflicting duties. And I'm not going to have a lot of detail about this, but I sort of have like three ways to sort of conceptualize this dueling function scenario. And it's something I want you to keep in the back of your mind because it's been one of the basis of many arguments about what is the appropriate way to enact probation from one jurisdiction to another. And whenever we think about should we make changes, oftentimes we come back to this central sort of discussion about these dueling functions that probation officers are faced with. In its simplest sense, one of the ways we may sort of conceptualize it is the necessity of investigating versus supervising as a probation officer. And if we think about that, these are somewhat conflicting at times. I mean, these two, we can see that they have some level of agreement, but as an investigator, you are delving deep into the facts. You are monitoring. You want to know the background of the probationer that you're working with. You need to investigate their life. You need to be sort of like digging deeper in it. In some ways, it's sort of an intrusive feeling for a probation officer to be that way towards their clients. And while at the same point in time, they also have to be a supervisor. They have to sort of make sure this person is getting the help and the necessities that they need. They need to be watching over them almost in a parental figure in that sense. So you've got on one side, you're sort of digging into all the details of their life and sometimes uncovering things that the probationer may not want found. While at the same point in time, you sort of have this parental figure to help them and guide them in the right direction. Another way of conceptualizing these dual functions for probation officers is to think about the conflict between the necessities of treatment versus surveillance, right? Treatment, on one hand, you want to assist these individuals, help them to get rehabilitated, refer them to treatment programs, help them battle their addictions or whatever they may need assistance with. And that way you want to be sort of caring and heartwarming and understand that oftentimes with treatment comes setbacks, right? Somebody goes into, whether they need help with substance abuse or whether they have anger management issues or whether they have trouble holding a job and keeping a job. From a treatment point of view, you have to understand that there are going to be setbacks at times, and you need to work with somebody and be allowing of those sort of failures in order to help them get better as they move forward. But at the same point in time, as a probation officer, you're also responsible for surveilling these individuals. And as part of surveilling them and watching their everyday behavior is you have to sort of identify and call them out and potentially even punish them for those failures, those missteps, when they fall back into using, when they act out in anger, when they lose a job because they failed to show up. So you have to punish them while you're also trying to treat them, and it makes sort of this very internal conflict that probation officers often face. And in the classic sort of way to conceptualize it is that idea of like trying to play the role of being both the bad cop and the good cop at the same time. And this sort of dueling function argument finds its way into sort of how we think about who would be the best probation officer. Should a probation officer be somebody who comes from a law enforcement background, where they've gone through the academy, they have some training as a sworn officer, and they are much more focused on sort of the investigation, the surveillance type aspect? Or would a better probation officer be somebody who comes with a background in education or a background in psychology or sociology or social work, where they have been trained how to not just recognize sort of failures and missteps that a probationer might do, but their focus is more on sort of treating them and supervising them and guiding them in the right direction. And this is an ongoing debate that we're not going to answer now, but it's something that I want to make you aware of and start thinking about when you think about who would be the best individual to serve in such a complex position as a probation officer. When we look at the research more and more, we want to have a connection between what the research tells us about what the best program or policy or approach might be in any sort of correctional setting. And with probation, there's no difference. There's been a wealth of research over the decades looking at what kind of approaches to probation work. One, as far as reducing recidivism of the probationers themselves. Two, promoting public safety. And three, sort of in a restorative justice point of view, sort of making everything a little bit better from a community point of view. Assisting the offender, reducing crime, promoting public safety, everything sort of put together. And in a nutshell, the research consistently tends to find sort of four components. And when approaches to probation and probation policies and programs tend to be able to successfully implement each one of these four components into their approaches, these seem to be the most effective sort of tactics used when trying to design and implement and sustain a successful probation approach. So the first component for a first evidence-based component is risk, and that is focusing programs on the high-risk probationers. Meaning, and this doesn't mean to not have a sense of equity or equality in how you sort of allocate resources and programs to probationers, but it's at the bottom line, it recognizes that in order to reduce recidivism, promote public safety in the aggregate sense, our programs and our specialized programs, our oftentimes most expensive programming, should really be focused on those that are at the highest risk of recidivating. More often than not, as we'll see, the majority of probationers are going to be fine. And I don't mean to say that in a callous sense. I think everyone, is going to need help and guidance. But a lot of people who find themselves on probation took a misstep, ran afoul of the law, got arrested, got charged, got convicted, and are doing everything they can from the get-go to get their life back on track and sort of put this chapter behind them. So they may not need all the resources and programs that other individuals who are higher risk might need. A second component for effective approaches is supervision. And once again, it's about where do we put our emphasis and our resources. And the focus of supervision, once again, should be on these high-risk individuals. So both the programs that will sort of help and are aimed at recidivism should be the highest risk group. The way in which we monitor and watch individuals, whether it be through mandated reporting to a probation officer, whether it be mandatory drug testing, etc., that those forms of supervision arguably should also be focused on the high-risk probationers. Research has found that for many probationers who are at what we would call the lower level of risk, too much supervision can actually be worse for them, because a lot of people are going to do minor things to run afoul of the law or violate the terms of their probation. And the argument here is that the more we are monitoring and supervising and watching and looking into the lives of individuals, we're likely to uncover some sort of misstep. And that may actually not bode well for both the progress and treatment and rehabilitation of the individual, and also it puts added burdens on the actual system if we're punishing people for every little minor misstep that they take. A third component is an effective approach to treatment. And treatment, once again, yes, it's going to be for high-risk probationers, but more importantly with treatment, it's the understanding that each individual has specific needs. And sadly, what we've seen both in the research and even in my own personal experience of conducting research in this area is that oftentimes some sort of treatment, some program, some type of therapy, whatever it may be, seems to work. And it comes out and the research shows that it's effective in helping people get jobs, it's effective in reducing recidivism, whatever else it may be effective at. And so this one treatment program seems to be great. And then the next thing you know, probation officers as well as the counties are trying to make sure that every probationer is getting this same form of treatment or this same form of programming. That's not effective. What is effective is to assess and identify the specific needs of each individual person. Now, yes, that's going to take a lot more time and energy and effort by the individuals working within the probation system. But at the end of the day, it's going to be a much more effective tactic as far as how we allocate resources and making sure that somebody is getting what they really need, right? There's no reason for you to have to go to substance abuse counseling and go to, therapy programs about substance abuse if you really don't have a problem there, right? I mean, all it's going to do is frustrate you and slow down your progress in areas that you really need help. And finally, one of the things, especially as we've seen the expansion in both in the complexity of probation, as well as just in the growing number of individuals under probation control in the United States, is the recognition that probation officers and counties cannot by themselves necessarily handle everything under one roof as far as how to treat, supervise, sort of identify risk of individuals. And therefore, this is where the collaboration with other community agencies outside of probation, outside of the correctional system, are very effective. And therefore, we need to have this idea of referral. The probation department should be able to assist in the referral process to treatment, once again, with recognition of specific needs, as well as understanding levels of risk and supervision. So what happens? What's the process of probation? Somebody ends up on probation. They've been arrested, they've been charged, they've been convicted of a misdemeanor or a felony. They find that the court imposes a term of probation on them. How do they get out of it? How do they get out of it? And what happens if they make a misstep? The next several slides are going to take a look at that in a very brief overview. So we're going to look at the termination and revocation of probation. So let's start with one. Successfully completing a probation term, right? So whether you're sentenced to 1 year of probation, 3 years, 5 years, and whatever terms and conditions you are imposed while you're on probation, somebody goes through, they go about their day-to-day life, they uphold and abide by all the terms and conditions, they meet all the requirements, they make it through the time period, and they successfully complete their probation term. That's sort of the gold standard, right? That's what we want everyone who is sentenced to probation to come out with as a success. And in fact, Roughly 2/3 of all probationers successfully complete their probation term, which is wonderful, right? I mean, that's kind of what we would think. If probation is ideally designed for lower risk individuals in the first place, we would hope that the majority of these individuals realize what they have done and are going to take steps in their life to once again put that chapter behind them and work to better themselves going forward. And we see that. However, if 2/3 of probationers complete successfully, we still have 1 out of 3 people, give or take, who don't. So let's talk first about what we call violations of probation. And the estimates are pretty broad. So estimates say that anywhere from one jurisdiction or time period to another, the numbers can be roughly 1 out of every 5 probationers violate rules of their probation, whereas other studies show that the number may be as high as 1 out of every 3 probationers will violate the rules of their probation. So what happens once you violate those rules of probation? So whether it's 1 out of 5, 1 out of 4, 1 out of 3 people, it's still a significant component of individuals who end up on probation violate their rules. So what happens? The next step we look at is how do you have your probation revoked, or what does that mean? And the most common reason for the revocation of probation is a new offense. Now, a new offense means that, in its classic sense, means that you've gone out and started engaging in criminal behavior again. And that is probably, if there's one key term or condition of probation, it's that don't continue to violate the laws. Don't engage in illegal behavior. And sure enough, the most common reason that we find across the board when we look at research studies on probation is that new offenses are that most common reason. But here's where it gets a little sticky. And this is what I'd like you to pay close attention to, what I've got, where we're going here. Just because somebody has been suspected of a new offense. So you notice I said suspected of committing a new offense. Now the probation officer needs to determine, do we let the court determine the outcome for the individual, where charges have to be filed, the person has their day in court, they have their plea, and et cetera, et cetera. So do we let the court determine the outcome to determine, did they really commit a new crime, or are they acquitted? And then there's no official new offense on the record. So that's one approach. So one path is that the probation officer can say, okay, we're going to hold back and we're going to let the courts determine whether or not charges are filed, and then what happens if they are, to see whether or not this individual really has committed a new crime. Or do we simply treat this suspected new offense as a technical violation? And we'll see this as a sticky subject both in probation as well as parole, and we'll see how it's manifests itself in parole later in the semester, but I just wanted to give you an idea on that. So somebody is suspected of a new offense. The probation officer has to make the determination, do we let the court determine the outcome, or do we treat it as a technical violation? So why do we have these two choices, and what are sort of the idea? Well, first of all, this opens the idea of discretion on the part of the probation officer. It gives the probation officer a choice. And some individuals would say that's the way it should be. That probation officer should know the probationer. They should know their job. They should know the appropriate approach. And therefore, they have the skill set to be able to make this decision. Do I let this particular situation go through the courts, or do I treat this suspected offense as a technical violation of the probation? Other individuals would argue against this discretion by probation officers because they think that discretion is a slippery slope to discrimination and unfair application of the approaches that are used by probation officers going forward. So this is a debate that we're not going to settle right now, but there is this level of discretion. The probation officers can determine which approach are we going to take. Are we going to pursue formal punishment, let it go through the courts, or do we treat it as a technical violation? What makes it extremely sticky is what we see here that just showed up there. There is a lower standard for both searches as well as for sort of, you know, coming to a final determination about guilt when we choose to either go through the courts or whether they choose to treat a suspected offense as a technical violation. If an individual is charged and their case goes to the courts, they have to be convicted beyond a reasonable doubt. The searches, the necessity for evidence raise up to the level of probable cause. However, it is much easier for a probation officer to obtain the evidence and reach a conclusion if they treat this suspected offense as a technical violation. And in fact, the thresholds for search as well as sort of declaring guilt are much lower if the probation officer treats the suspected offense as a technical violation. They simply have to look for, reasonable suspicion in order to start obtaining evidence from the probationer. The level of determining guilt is much lower, and they can say, we have suspected that you have engaged in criminal behavior, and therefore that is a violation of your probation, and therefore we're going to move on to treating it as a violation in the next steps. So I hope you kind of get that idea. This is an ongoing debate of what is the better approach. Obviously, if a suspected offense goes to the courts, it's going to be more time consuming, it's going to be more expensive, it's going to sort of delay the decision making for what is the future for that individual who is sitting there on probation, not certain whether or not they're going to remain on probation, whether their probation is going to be revoked, or not knowing the outcome, right? So the courts are a longer, more expensive, but many people would argue much more of a safeguarded approach with built-in safeguards like due process, etc. Whereas treating a violation as a technical violation is much quicker, much more efficient. We get to a final resolution much quicker, so everyone can kind of move on with their life. But people would argue that because there are lower standards for both search and guilt, that it opens the door for discrimination and unfair practices by probation officers. So now that we've moved past that sticky subject of how do you treat a violation of probation, especially when it is suspected of being new criminal behavior, let's look at the process of revocation. So once an individual is facing potential revocation of their probation, the first thing is a preliminary hearing. A preliminary hearing to make sure there's enough evidence to move forward. Oftentimes this is waived by the part of the probationer themselves. And as with most preliminary hearings, we can see that the facts are reviewed to determine probable cause. Then there is the official formal hearing for revocation. After that hearing, it is determined whether or not an individual has truly violated the terms and conditions of their probation, and then the judge gets to make the determination of how they're going to move forward with that individual. And in a few slides we'll see a little bit more details about this process of revocation with a specific lens on California, so sort of hold back about that hearing and sentencing to that point. But let's take a quick look at sort of what the judge is able to determine at sentencing for a probation revocation. So they can decide, do I need to impose a term of incarceration for this individual? Do I simply just return this person back to their normal probation? Or do I return them back to their normal probation, but do I add additional terms and conditions and requirements for that particular probationer? Or could I sort of mix all these together? Could I impose a term of incarceration followed up by a probation term with additional terms, right? So you can see there's a sort of a puzzle of many pieces that the judge can sort of choose from and put together in determining what they believe is the best approach moving forward for this particular individual. We've seen a background of what probation is. We've talked very briefly about sort of the growing complexity of probation. We've talked about what the research says about what are some of the key components that make various probation programs and policies more effective or less effective than others. And then we've also seen an overview of sort of the process of how individuals sort of navigate a probation sentence as far as with specific focus on violations and revocations of probation. So let's take some of these ideas and let's take a look on these last few slides to imagine somebody in California. So the first thing is somebody is charged with a crime. They are, have their court date. They have their day in court and they are convicted of this crime. They are sentenced to probation. Well, the first thing we have to differentiate, because not all forms of probation are the same. In the simplest sense, there are sort of two major forms of probation in California. And are there much more forms than two? Yes, there are, but we're not going to go into all the various forms of specialized caseloads and all the nuances. We're simply going to take a look at the two general forms of probation in California. So first, we have what is often referred to as either summary or informal probation. This is typically reserved for individuals who have been convicted of a misdemeanor. So remember, a misdemeanor is a much lower level crime that is usually punishable by fines, probation, jail time, and usually the overall sentence, if it's incarceration, is under 1 year. When an individual is sentenced to informal probation, sort of the terminology that we often see used is that this individual has been granted a suspension of their sentence. So suspension of usually what we would call like a jail sentence. So the judge has agreed to suspend that jail sentence so long as the individual abides by rules, abides by the laws, and also follows any necessary terms and conditions of probation while they're in the community. Now, obviously, if somebody violates any of those things, the judge can then now impose their original sentence and have them incarcerated. For informal probation, oftentimes there is no official probation officer that the individual has to report to. Rather, they just have to, they've got their set of terms and conditions. They've got their paperwork that tells them what they need to do. They know when their next court date is. They know whatever sort of requirements they're supposed to do, as they move through their probation, and they kind of do it on their own without sort of having this supervisory probation officer looking over their shoulder. And informal probation sentences typically are imposed for somewhere between 1 to 5 years. And obviously the factors that go into determining the length of informal probation are going to be the type of crime, mitigating or aggravating circumstances surrounding the crime, the personal history and or needs of the offender, etc. On the other hand, or the second type of probation that we have in California is what we call felony or formal probation. Now, as the name implies, this type of probation is for individuals who have been convicted of a felony. And so oftentimes what we see here is this is going to be a much more severe form of probation. There's going to be additional supervision by a probation officer for individuals serving formal probation. There's also going to be a lengthier list of terms and conditions for the probationer that they have to meet. So additional supervision, additional conditions, supervision by a probation officer. And the typical sort of range that we see for formal probation our range is usually from 3 to 5 years. And similar to what we saw with informal probation, if somebody were to violate the conditions of their probation, then they will return to court, go before a judge, and the judge can decide to continue with probation, can send them to prison, can send them to jail for a while, and then return them to probation, or a multitude of other approaches. So once we've determined what kind of probation somebody is on, whether it's informal probation or whether it is felony probation, formal probation, we think, well, how does somebody even violate their probation in and of itself? And I've spent the first part of this lecture focusing on the most common form of probation violations, which arguably are new offenses. But as we'll see with this lengthy laundry list that I'm about ready to show you, committing new crimes don't really show up until the very bottom. And you can start to see that simply being on probation, all of a sudden, many things that would be either legal for the average citizen can become something that is potentially a violation that can lead to, a heightened level of punishment. Or even if they're not illegal, there are things that many people get away with, quote unquote, in everyday life simply because they're not being supervised at the level that individuals on probation are. So let's take a look at the laundry list. And this is just, once again, just a small snapshot of the types of things that individuals can for reasons that they can have their probation violated. Failure to pay fines. And so what happens if you don't have the money? Well, you're in violation of your probation. Failure to complete any programs, right? So if you're not showing up to counseling or therapy or treatment or whatever it may be, that can be a violation of your probation. Failure to complete any classes, like educational requirements that you may have with your sentence, right? So it's not just the fact that you decide like it's too hard or I can't balance my treatment schedule with my work schedule, with my life schedule. And so I'm going to try to drop out of these classes because I'm too, my plate is too full right now. No, if that's part of your terms and conditions, you've got to not just show up, you've got to complete them. If not, you're going to be in violation of your probation. Failure to complete community service. Failure to submit drug testing, right? If you don't even show up for drug testing, that is a violation of your probation. Obviously, if you drug test positive, that's going to be a violation. If you violate a protective order, if you fail to appear at a scheduled court date. And sadly, we talked about this briefly when we referred to bail, but one of the most common reasons that individuals are found to be in violation of missing a court date and a bench warrant is issued, violation of probation meeting or date and a bench warrant is issued, is because they forget to show up. And they're seen as an absconder, somebody who is hiding, right? And therefore that is taken very seriously because they don't know the rationale. The court doesn't always know why you didn't appear. And this is why sometimes simple things, as we start to think about the benefits of technology, a text message, a postcard, an email, things like that can often increase appearance rates in and of themselves without having to resort to treating them as violations. Also, failure to notify your probation officer that you're traveling out of state, right? You need to let them know in advance. Sometimes you're even limited to, remaining within the county. Failure to notify a probation officer of an arrest or even a minor police contact if you were let go. You don't want somehow communications, you don't want your probation officer finding out that you were stopped and questioned by police. That doesn't bode well for you. Even if you weren't formally arrested, you need to let your probation officer know. Failure to notify your probation officer of possession, use, or sale of illegal drugs. We can kind of see where that one, you should probably should not be doing any of those things, but you can see why failure to notify is just going to get you in that much more trouble. Obviously, same idea here. Failure to notify a probation officer of the fact that you've committed a new crime. If they find out, they're going to take it that much harsher on you. Something as simple as failing to report for a scheduled meeting. Once again, that idea of missing a meeting, missing a court date. I don't know an estimate, but you would think the money we could save with efficiency and going forward would be great if we could just get everyone to show up when they're supposed to show up. And then finally, at this very long list of potential probation violations, we finally see that commission of a new crime and being arrested and or charged with a new criminal behavior. So you can start to see that simply because somebody's on probation, there are many ways in which somebody can take a slight misstep, even though they're trying to do 99.9% of their day-to-day life the way they're supposed to. One slight misstep can have you as a violation of your probation. So what happens? What happens once you actually violate your probation? And I apologize for making this such a wordy slide, but it kind of gives you a general breakdown. Once again, it's sort of simplified, but a general breakdown of what happens in California if you are found to be in violation of your probation. So you violate a term or condition of your probation officer notes it, files a report. That moves up the chain of command and it makes its way to the court, and you are then required to appear in court. That's our little green box on the left that we start with. So from there are sort of three things that can happen once the judge hears your case and hears about your suspected violations. Let's start with the top, the yellow boxes. The first thing that can happen is the court does not violate you. So simply put, the judge does not find you in violation of your probation. Therefore, your probation remains the same. You walk out of that court and you go back to living your life with the same terms and conditions that you were living with before you walked into court. And one of the interesting things here in California is if you're able to stay in that yellow tier, even if you're suspected of a violation, you still remain eligible for expungement upon the completion of your probation term. And if you're not familiar with expungement means that you can formally request the court to have pretty much that criminal behavior wiped from your record, as if you were not convicted, you did not serve time for it. So the ability to be eligible for expungement once you successfully complete a probation term is very important for many people, right? It clears your record. It alleviates you from having to declare it in future, job interviews or employment processes or other types of things. So we can see why that's an important thing. The second sort of approach that the court may go with is what we see there in sort of the orangish boxes there in the middle. In this case, the court violates you, found that there's enough evidence to declare that you have quote unquote violated your probation, but they choose to reinstate you. So what does this mean? So the judge finds that you've been in violation of your probation, but the judge can either choose to reinstate your probation and your probation remains the same. So you leave the court and you go back about your daily life, or the judge can choose to reinstate your probation, but modify some of the terms, right? So they may add additional drug testing. They may add additional counseling. They may add additional curfews or restrictions, things of that nature. But yet you still stay, quote unquote, on probation, you walk out. The negative part of this sort of middle level, this orange level, is that once you have been found to violate your probation, you are no longer for expungement. So you're no longer able to have your record cleared once you do finally complete your probation term. And then finally, in the red at the bottom of the slide, we see what happens when the court both violates you and officially revokes your probation. So in this case, the judge finds that you are in violation of your probation and he or she chooses to revoke your probation. What does this mean for you? Well, you can be sentenced to serve jail time, like a short, a month, 2 months, 6 months, whatever it may be, jail time. And then upon release, you continue on with your probation. Or the judge can choose to have you sentenced to the incarceration time that you would have faced when you were originally convicted, prior to you being sort of deferred to probation, right? So at the time that the way that you got, oftentimes, like especially with felony probation, you're convicted of a felony. So the statutes and the laws say that you face X amount of time in prison. But the judge feels that for various reasons you are eligible for felony probation. Therefore, you remain in the community. Well, if you are found to violate your probation and the judge revokes your probation, they can go back to whatever your original prison sentence would have been and choose to sentence you to that time. And at that point in time, they just say that your probation is terminated because you have moved from one form of punishment to a different form of punishment, which is incarceration. And then also with this red one, if you fall into that category, you are not eligible for expungement. So I'm going to wrap it up there for today, and that just sort of gives you an idea of sort of what we think about when we see and understand how probation works here in America and in California in particular. I hope you enjoyed the lecture. Have a good day.